560 United States of America versus David Taylor.
Good afternoon, Your Honor. Sarah Cohen appearing on behalf of the United States.
Good afternoon.
Good afternoon, Your Honor. Scott Rosenblum appearing for Pastor David Taylor.
Okay, good afternoon. Mr. Taylor, can you please approach and state your name for the record?
David Taylor.
Okay, thank you. Today is the date set and time for an arraignment and a detention hearing. Let's do the arraignment first. Mr. Taylor, did you get a copy of the indictment?
Yes.
Okay, you need to speak in the microphone.
Yes,
Okay.
Your Honor.
Okay. I do have in front of me an acknowledgement, and it's signed by you and your lawyer. Is that right?
Yes, Your Honor.
Okay. And this document states what you have been charged with and the maximum penalties you could face if you are convicted or plead guilty. You've been charged in this indictment with count 1, conspiracy to commit forced labor in violation of 18 U.S.C. section 1594. That carries a potential maximum penalty of 20 years imprisonment and a fine of up to $250,000. Counts 2 through 9 charge you with a violation of 18 U.S.C. section 1589, which is forced labor. Each of those counts carries a potential maximum penalty of 20 years imprisonment and a fine of up to $250,000 on each count. You've also been charged in count 10 of this indictment with conspiracy to commit money laundering in violation of 18 U.S.C. section 1956. That also carries a potential maximum penalty of 20 years imprisonment, a fine of up to $500,000, or twice the value of the properties involved in the money laundering transactions. You also need to understand that the court could impose consecutive sentences if you are convicted of more than one count. Mr. Taylor, do you understand what you've been charged with in this indictment and the maximum penalties you could face?
Yes, Your Honor.
Okay. Counsel, are you ready to enter a plea?
Yes, Your Honor. We'll waive the formal reading of the indictment and enter a plea of not guilty to each count.
Okay. I will enter a plea of not guilty on each count, and the record will reflect that Mr. Taylor has now been arraigned on the indictment. So the next matter is the detention hearing. And before the government starts its proffer, I just want to put on the record that in advance of this, I've reviewed not only the indictment, but I've also reviewed the memorandum that the government filed in support of detention. I've also reviewed defendant's memorandum in opposition to detention that have been filed, as well as obviously the reports of pretrial services, both from this district and the one that was prepared in the district where he made his initial appearance. So just so you know what I have reviewed, and I am also familiar with the proceedings with the co-defendant. So go ahead.
Thank you, Your Honor. With that recognition by the court, the government's argument today and factual proffer will be limited. As the court is well aware, Taylor is charged with forced labor, and Congress requires a presumption of detention. This presumption reflects Congress's substantive judgment that particular classes of offenders should ordinarily be detained prior to trial, such as David Taylor. It is the government's argument that the defendant will not meet its burden of production. However, if the court finds otherwise, the government's argument today will focus on 3142 factors, beginning with the nature and circumstances of the charged offenses. According to the evidence presented to the grand jury and reviewed by this court, David Taylor was a self-proclaimed general of a very unusual and brutal regime. And he was, according to the evidence, a serial sadist. And that is no exaggeration. For 11 years, in 4 states, over a decade, he terrorized and traumatized workers with violence, threats of violence, sleep deprivation, medical deprivation, and food deprivation. Contrary to the defense brief, victims and witnesses will testify that David Taylor, defendant number 2, Michelle Brannon, and others in the organization, including some who are sitting in the courtroom today, assaulted others in the organization, including, to date, at least one minor who has come forward. Specifically, witnesses thus far who have been willing to come forward have reported that approximately 10 members who have assaulted other people within the organization. Because of the nature of the public proceeding, the government is not going to identify those people at this time, but there are approximately 10, again, including some seated in this courtroom today. Victims and witnesses will also testify that they were deprived of food, sleep, and medical care. Their testimony is corroborated, overwhelmingly, by Taylor's orders and threats to his victims that have been documented. For the record, the government is going to place some of those threats directly from Taylor into the record, notably with the times. Beginning on just one at 12:26 a.m., Taylor texted an armor bearer. As the court knows, an armor bearer is Taylor's personal slave. He instructed the armor bearer as follows: "You'll have to raise $164,000 today." To clarify, the armor bearer was responsible for passing on that order to the workers. "Each hour you will fall behind, consequences will start. We will mess with the food. You will fast from the regular food or abstain for a while. Those who do not push in their calls individually and as a team with the right amount of people and closing numbers at 6 p.m., they don't eat dinner at all. They might get a snack before bed, but not much, and this regiment will go on every day for 21 days until they obey. Take away the food. Exclamation point, exclamation point. There will be other consequences. We must make them fast and pray." Another one at 3:55 a.m., Taylor texted the same armor bearer: "Those in the top 9 that don't do well will stay up and close and stay on top of the delinquents. Put the pressure on them for not having their time off. Nor food. They will fast." At 3:52 a.m. on another date, Taylor texted his armor bearer: "Let everyone know we have to raise at least $50,000 by 12 midnight if this happens. The top 9 and those who did well can rest, but the others who didn't will stay up until 4 a.m. and study notes, and they will wake up at 8 to 9. And if they don't do good the first 5 hours, they will not get lunch." On another date, 7:57 a.m., there is evidence of consequences when people are sleeping and are having a hard time waking up. He texts his armor bearer: "Pour water on everyone's faces that's halfway sleeping and not working. Wake them up now. My next level of judgment tomorrow is that it won't be just 4 a.m. It will be every hour you waste in the day will be added on past 4 a.m. In all capital letters, tell them all to stand now and you throw water on their faces." Later in the text, "You tell them I don't care about them being sick." On another date at 3:23 a.m., Taylor texted to his armor bearer: "I can't be kind to you letting you start later and sleep in. I can't be kind with none of you. You're all working until 4 a.m. Now, I don't care if you're tired. You've crossed the line. You're going to work all night and get up in the morning." In another text, Taylor texted a group of workers: "You're not going to bed tonight until you raise $33,000. And as the court knows, the $33,000 and all the other money that Taylor is insisting being raised is not for the benefit of the community. It is for the benefit of David Taylor and Michelle Brannon. On another date at 1:44 a.m., Taylor texted a group of workers in capital letters, point blank: "If you don't work, you can't eat." On another date, Taylor texted a group of workers, warning to the whole staff in capital letters: "If you don't work and learn closing like we told you, then you won't eat." There are more. They are in the brief, and there are more in evidence. In addition to the threats that are corroborated by victims and witnesses, FBI agents are now investigating even more disturbing evidence in addition to the forced labor.